Hello, welcome. Happy Halloween. This is Professor Guerra Pujol at the University of Central Florida, and welcome again to Legal and Ethical Environment of Business. We're right in the middle of Unit 5, and we've been talking about ordinary civil litigation. We've talked about, I like to look at the litigation process as a three-act play, and we've already talked about Acts 1 and 2, the pleadings and then discovery. What remains is the third act, and that is when a case goes to trial. And by the way, even when we have a jury verdict in a civil case, either finding a defendant guilty of some, civil, breaching some civil duties, whether they be breach of contract or committing some torts, or whether the jury finds the defendant not guilty, if the case is important enough, it might get appealed by the losing side. I will tell you, right, an appeal, just generally speaking, in civil litigation, a party has one appeal as of right, which is generally to the appellate court, the intermediate court. Then, if you want to further appeal up to the state Supreme Court or the United States Supreme Court, in the case of a federal case, then that is discretionary. The Supreme Court, state or federal, is not required to review an appellate court case. But there is usually one appeal as of right to an intermediate appellate court. And as you can imagine, that can add to the expense and the time of a litigation, of the case getting resolved. The main thing I want you to know about appeals is that the appellate court, as a general rule, cannot go over the facts of the case again. That's the jury's job. What the appellate court can do is only see if any errors of law were committed. And generally speaking, courts have various standards of review. Sometimes it's the clearly erroneous standard that an appellate court will only overrule a trial court if the trial court has made an egregious or big mistake in interpreting the law or applying the law. Oftentimes, the standard of review is de novo, where the appellate court will just look at it with a fresh set of eyes and decide whether the trial court made a mistake or not, but not look at the magnitude of the mistake. But I don't really want to say that much about trial and appeal because in reality, very few cases, and this includes business litigation, business cases, do end up going to trial. A lot of cases either end up getting settled out of court or maybe dismissed by the court if a motion to dismiss is filed, or alternate methods of dispute resolution are used to resolve the case, which will take the case outside of the ordinary purview of litigation in most cases. So what I actually want to do in this concluding lecture for our Unit 5 is just talk about the main methods of alternate dispute resolution. I'll just go ahead and do that now as opposed to creating a new video. And I just want to let you know that the two main methods, now there are other methods as well, but the two big ones, I just want to let you know the major methods are mediation and arbitration. So let me talk about mediation first. Mediation is very common. It actually originated in the area of family law. Divorce proceedings and child custody proceedings can be very contentious, very emotional. And so in the 1970s, in family law cases, judges would ordinarily recommend mediation as a way of amicably resolving differences and lowering legal costs. Now, I will tell you, in almost all state and federal courts, whether it's a family law case or a business law case, either as a matter of local rule or at the judge's discretion, a mediation will often be required as a condition before a case goes to trial. In fact, I will tell you, in the Connect You versus Facebook case that we've been talking about in this course, that case went to mediation. I'll also tell you the Mike Tyson tattoo case that we looked at in our class session number 2. Those cases went to mediation and they were resolved in mediation, so they never went to trial. Mediation is very common then. All you need to know about mediation is that it's non-binding, and although your parties are required to go to mediation, they're not required to accept any recommendations made by the mediator. The way generally mediation works is that the court which is requesting or requiring the mediation, will often have a list of court-approved mediators ahead of time. Most of these are trained lawyers or have trained in psychology as well. And what they generally do is they will meet with the parties together and then meet with the parties in separate rooms separately. And then try to facilitate areas of agreement between the parties. This is very informal. It's just an idea to see, can the parties reach agreement? Where can they find agreement? I will tell you, I find mediation and negotiation generally to be fascinating because it's so unpredictable, it's so dynamic. But the main thing you need to know about mediation is that it's, even when the court requires that the parties go to mediation, the parties are not obligated to accept any recommendations made by the mediator. Mediator is just there to try to facilitate an agreement, try to avoid the parties having to go to trial. But if an agreement cannot be reached, or if either or both of the parties don't accept the recommendations made by the mediator, then they can still go to trial. Now, this is vastly different to arbitration. Arbitration is generally binding, although there are forms of non-binding arbitration as well. If you want to take a look at how arbitration works and you use Instagram, for example, go to Instagram's terms of use and you'll see an arbitration clause in there. In fact, arbitration is becoming more and more common in many business to consumer agreements and contracts. It used to be, I will tell you, that arbitration was really used, for example, when labor unions had their collective bargaining agreements with the corporations they worked for, or some, if you're into sports, the National Football Players Association or the Major League Baseball Players Association or the NBA Players Association, they have collective bargaining agreements with their respective leagues. And usually those collective bargaining agreements have these binding arbitration clauses. Now, whether a case goes to arbitration or not depends on, do the parties have an arbitration agreement ahead of time? If there's no arbitration agreement, then usually the case will go into ordinary civil litigation. There might be mediation as part of that litigation process. Certainly there may be informal settlement talks between the parties, but there will be no arbitration. So arbitration does require a contract with an arbitration clause or an arbitration agreement. And as per the terms of the Federal Arbitration Act, which was enacted by Congress in the 1920s and is still on the books today, both state and federal courts are required to enforce, as a general matter, arbitration agreements. Now, the Federal Arbitration Act and the case law interpreting the FAA, Federal Arbitration Act, do have some exceptions. For example, if fraud was committed on the part of the arbitrators, there are these narrow exceptions, but that's going to be very, very hard to prove. Generally speaking, arbitration agreements are considered enforceable. Oftentimes, before the U.S. Supreme Court, there are cases challenging the enforceability of certain arbitration clauses. For example, punitive damages. Do you waive your right to punitive damages? What about class actions? And those cases the Supreme Court has been deciding. Recently, they've taken some pro-business decisions enforcing those type of arbitration agreements, limiting the rights of the parties. So you always have to be careful before you sign an arbitration agreement, what it is you're agreeing to and what rights you're waiving, because arbitration agreements, as I said, are considered enforceable. Now, the main thing about arbitration, especially binding arbitration, is what it does. It cuts out the discovery process. When a party files a claim with an arbitration panel, an arbitration, I will tell you, it's a completely private system. The most important arbitration organization is the American Arbitration Association, or AAA. When a party files a claim with an arbitration panel, then the arbitration panel will schedule a hearing. And while attorneys are not required to be present at the hearing or to present arguments, generally speaking, in important cases, the parties will be represented by attorneys and there'll be a hearing. And then the arbitration panel will reach its decision. Now, here are some salient differences between arbitration and civil litigation. In addition to the fact that generally speaking, there's no discovery process. So arbitration is faster and therefore cheaper and quicker than ordinary civil litigation. That's That could be on the pro side of arbitration. On the con side or against side is that generally speaking, arbitration panels, when they make a decision, those are not part of the public record. Those are not, oftentimes the arbitration panel will make a decision without giving a formal opinion. And so that's different from the courts. When courts rule on matters of law, oftentimes they will render an opinion explaining the reasons that they give for reaching the decision they made on a question of law. Whereas with arbitration, right, the system of stare decisis and precedent and published opinion, you don't have all of that. And so it's more opaque, less transparent. But the main thing with arbitration, and the reason why a lot of businesses are now inserting arbitration clauses into their agreements, even in their agreements, consumer agreements, is because it tends to be faster and cheaper than the ordinary civil litigation process. So it's just a question of weighing the pros and cons. Now, what's interesting, I mentioned Instagram's terms of use. If you look at Facebook terms of use, they don't have an arbitration agreement, at least not yet. They have a forum selection clause, something I'll talk about in a future video, but they don't have an arbitration clause. And I find that to be quite interesting because, as you know, Instagram is now owned by Facebook. And so I often wonder if Facebook is running some kind of experiment just to compare the costs, of civil litigation in their Facebook lawsuits and the cost and outcomes of, arbitration in their Instagram disputes. Of course, I'm not privy. That's could be private information. I don't know off the top of my head, but that's something to keep an eye on to see, will the Instagram agreement be eventually revised to take away the arbitration clause, or will Facebook agreement be revised to include an arbitration clause? That's an interesting strategic question that they have to decide. Well, with that, we conclude this unit of the course. The main point to know is that the ordinary civil litigation is time-consuming and expensive because it consists of these three big stages. The pleading stage, the discovery process, where you have a lot of depositions and request for production of documents, and then the trial phase and possibly an appeal. And then we concluded by noting some of the major methods of alternate dispute resolution as a way of avoiding the expense of ordinary civil litigation. Oftentimes parties will either mediate their disputes or arbitrate their disputes, just to give you the big picture. Well, I know this has been a lot of information. I'll let you digest it. Let me just thank you for your time and attention, and good luck and go Knights.